In accident benefits claims, everything is very paperwork oriented. It's a bit of a paper war, and unfortunately it shouldn't be a war because the insurance company that you're dealing with is your own, and that's who the contract is actually with. It's between you and your insurance company. That being said, not every claim that gets presented to an insurance company is something that they have to pay for. So what happens in the system of accident benefits is you have treatment plans, you have various forms that have to be filled in and submitted to an insurance company, and what will happen is those things get submitted, they all get submitted through a special system in Ontario, they get considered by your insurance company, at which point they have three options. They will either approve the entire treatment plan or proposal as submitted, or they will approve a portion of it, or they will not approve any of it. That's very concerning for people when a treatment plan or some other form of benefit has been denied by their insurance company, and they say they constantly live, because you are sort of relying on these benefits to get back to your normal life, people have big concerns about what happens if my insurance company denies this benefit, and that's a legitimate concern. What happens is it becomes you can go through a process where you ask the insurance company to reconsider paying for that benefit. You can present them with more evidence, you can give them, better medical information to help them reconsider their decision, but that may not always be successful, unfortunately. Even though the treatment may be legitimately required, sometimes this gets back to the situation where you are essentially just a pile of paper on an insurance company person's desk, and they don't always think critically about what you may need or why you haven't gotten better when, perhaps their mother or their aunt did get better in that same circumstance, so they want to apply the exact same test to you that perhaps they've seen in the past, even though your circumstances may be different. So what happens in that case, if you've presented additional information or you've tried to go through the process in a conciliatory fashion with the insurance company, then what you may need to do next is you may have to file what is called an application for mediation. The Financial Services Commission in Ontario is the government body that is responsible for regulating the insurance industry, and that includes auto insurance. They are also responsible for helping to settle disputes between consumers and the insurance industry. So what happens in that case is you file an application for mediation, or you would probably want some help with that. It can be a bit of a daunting process. At that point, you're into a dispute with your insurance company, so there's a good chance you're going to want to get some advice at that point anyway, even if you haven't had any up until then. And you will have a form prepared, it's the application for mediation, which sets out the various issues and why you say that the dispute has come about with your insurance company. Once you go through that, that's a mandatory process. You can't opt out of it. You can't run off to the courthouse or to an arbitration process until you get through the mediation process. The whole point of the mediation process is designed to have somebody who is a neutral third party sit down with people who may be entrenched in their positions and say, let's try to think about this again. Let's try to think about it in a different way, and maybe we can come to some kind of agreement that works for the parties. The problem with that process is that if it's not successful, there's no finality to that process, because the person that is sitting down with you can't make decisions for you that are binding on anyone. Their job is just to try to make the parties get closer together in their positions to see if they can come to an agreement on their own. Unfortunately, there's been a huge backlog at the Financial Services Commission since probably about 2006, when a number of changes were made to the auto insurance product. And what has happened is there used to be a system that settled disputes much quicker than what happens now. And after 2006, when that process was eliminated, everybody had to line up for the mediation process ahead of being able to actually have a dispute settled with their insurance company. What follows mediation is there's a two-pronged approach. You can either have an application for arbitration, which again goes to the Financial Services Commission of Ontario, except in their capacity in dealing with those types of applications, they do have somebody who can make final decisions for the party, who acts essentially as a judge. In this case, it's an arbitrator. And the decisions of the Financial Services Commission through the arbitration process are final, although they may be subject to appeal if you believe that the decision is wrongly made. The other option that you have, if mediation is unsuccessful in settling your claim with your insurance company after it's been denied, is you can go to court and you can essentially sue your own insurance company for the benefits that you believe that they should be paying for to help you get back to your normal life and to recover. It's unfortunate that sometimes it comes to that, but it does on a regular basis. And those are essentially your options in a nutshell when your claim has been denied for accident benefits.